I am extraordinarily honored and quite excited to have a chance to talk with four terrific judges, three of whom served as chair of the U.S. Sentencing Commission, and one of whom has written an awful lot about the work of the U.S. Sentencing Commission. And without a lot of ado, I want to get right to the heart of some questions that they can share their wisdom. And the first one is to really have them reflect on their time on the U.S. Sentencing Commission and what they thought were some of the most sort of important work that they did through the commission that they think can inform the work of future commissions, really reflecting on their time. We'll go chronologically with Judge Hinojosa, then follow with Judge Session, and then move to Judge Saris.
Well, I just want to say something about me before we get into it, about my knowledge of the sentencing process. I'm probably the dinosaur in this group because I actually was a judge for about 4 or 5 years where we had no sentencing guidelines. And that system to me was a difficult one from the standpoint of me trying to be consistent with my sentencings, to the point that I would be looking for prior cases that I had or try to figure out what other judges and the other judge was doing in my same courthouse. And so when the guidelines came into effect, I was one of those that was not upset about it at all. In fact, I thought it was going to be helpful, and it has proven to be helpful. And to be quite honest, my work on the Sentencing Commission came as a result of my being asked if I would like to be a circuit court judge. And I said, no, I'd rather be on the Sentencing Commission. Nobody sent me for observation and study to try to find out if I was okay mentally. But I was quite sincere about that. I was not interested in a circuit court appointment. I was certainly interested on the Sentencing Commission, and that's how I got on the Sentencing Commission. Actually served there from 2003 to 2014, which is basically about 2 terms. And what was important to me from that standpoint is I'm on the border, heavy criminal docket, which is different probably than most criminal dockets in the sense that we have a lot of non-citizens go through our criminal docket here. And actually the statistics from the commission show that a large percentage of the people that are being sentenced in the federal court system are non-citizens of the United States. And since I have a varied docket of criminal cases, whether it's fraud, whether it's drugs, whether it's illegal reentries, whether it's transporting aliens, harboring aliens, all sorts of different varieties, there's not a specialty here. I felt the commission was important from my standpoint. And I was one of those individuals that when the commission was created, I was not thinking of, oh my God, somebody's going to be telling me something that I already know. Why should I be following guidelines or anything else like that? In fact, it made me feel a lot more comfortable to know that these were national considerations and that everybody across the country was going to be looking at the same kind of factors and then making an ultimate decision based on the case in front of you. I never found that to be a problem. In fact, I found it to be helpful. And that's one of the reasons I wanted to be on the commission, to bring this viewpoint from the southwest border as to the many cases that we handle and what, if anything, we thought should be changed within the guidelines or looked at more closely. And I was very fortunate to be on the commission and enjoyed working with people that I may have disagreed on. It is a commission that works on consensus. It is a commission that gets input from all sorts of sides before it makes a decision, including public hearings before it makes a decision on what the guidelines should be if there's going to be any changes. It isn't just a group of people that say, okay, let me do this and that, without having a serious study with a staff that is quite capable, information that is given because everybody has to send its information with regards to every sentencing. And so the amount of information at the Sentencing Commission office that is gathered and used is extremely helpful with regards to whatever the commission does with regards to sentencing, to say nothing of obviously whatever Congress is doing and the importance of that. And it was important from my standpoint as chair that we had a good relationship, try to deal with all sides in Congress and make our presentations and information and testimony informative with regards to what we were doing.
No, that was terrific, Judge Hinojosa. I really appreciate that. Judge Sessions?
Yes, thank you very much for asking me to participate. And it's really quite a thrill to participate with all of you. So I started in 1999. I was appointed in 1999 as a part of that big group, 7, and became chair in 2009 and ended in 2010. So it seems to me that first, the contribution that the initial members made was to reestablish the commission. The commission had actually stopped functioning when it made a recommendation to Congress to equalize powder and crack. As a result, none of the commissions were reappointed, and the commission actually dissolved. We were appointed then, knowing full well that there is that sensitive relationship with Congress. And one of the first things, perhaps that I'm also proud of, is that we established a tradition of working by consensus. It is a political world. It is a world that is a part of Washington, D.C. And the fact that we worked by consensus, both almost an equal number of Republicans and Democrats, theoretically, gave us credibility. So I guess the thing that I'm most proud of is the crack -2. It was in 2007. We took the crack guidelines, which again were established based upon the tradition of having the sentencing range of a particular offense at the top end of the guideline range. We, as a group, concluded that we could reduce the crack penalties by 2 levels, which reduced the average sentence by 33 months. But we did that after study and after consultation with Congress. We did it very deliberatively and with the consensus of the group, although I think eventually the vote, as I recall, was 6-1. And then establishing both that sense that we could reduce guidelines by 2 levels, which of course was applied later by a later commission as well in drugs. We also established the fact that these changes could be applied retroactively. And this was somewhat controversial at that point in 2007, but we applied all of the changes retroactively to people who were in prison, reducing sentences fairly dramatically. And then we had a study to determine whether this impacted the recidivism rate. It did not. And we were quite happy about the fact that we could, in fact, at least to some extent, reduce the disparity with crack and powder sentences and not dramatically impact the issue of safety in the community. And the other thing is, when I was chair, of course, this was applied to mandatory minimums with a change in the statutory mandatory minimums implemented by Congress. We assisted in that. But also what I was most excited about in the time that I was chair was to actually begin to open up the guidelines to consider alternatives to imprisonment. And in fact, we changed some of the language of some of the enhancements and guidelines to suggest that in situations in which alternatives to imprisonment were called for, that judges, in fact, be encouraged to do that. Again, this is the post-Booker period. This is a period in which more discretion is being given to judges. But the fact that the Sentencing Commission would actually have language in the guidelines to encourage thought processes which would enhance the use of alternatives to imprisonment was quite important for me. And that's something I took great pride in.
Wonderful, Judge Sessions, and compliments to both of you in keeping on time. And I'm sure Judge Saris will continue that tradition as she tells us about her time on the commission.
Well, thank you very much for inviting me. And it's great to see all my old friends here, even if it's on Zoom. So I became the chair right after Judge Sessions in 2011. And I had been nominated by President Obama, confirmed by the Senate. And I was eager to do it because I had worked on the Sentencing Reform Act of 1984 when I worked for Senator Kennedy. Then the issues were disparity, unwarranted disparity, both within a courthouse and across the country, and disparity involving demographic disparity. When I got there in 2011, though, the discussion was actually had shifted, because I got there at the time when mass incarceration was peaking. The prison population was in the federal side was in the vicinity of about 217,000 people. And of course, it was huge in the local and national state level as well. And we at the time, starting with an initiative I think Judge Sessions mentioned, but also building on what Judge Hinojosa did in crack, started looking at drug sentences as one of the primary drivers of mass incarceration. We also learned a lot from the states. I think that's really important to know. I mean, we built on what Texas did and Maryland did and many of the states across the country, and looked at, are there ways that we can do this better? And that was did intensive study. As you've heard, we're totally evidence-based. We have these big staffs that look at data. We have hearings, and we began an initiative which colloquially became known as Drugs -2. And we reduced all drug sentences across all drug classes and made about 40,000 people eligible for, on average, a 2-year reduction. Not all got it, because each judge had to look to make sure that public safety was being protected. So it wasn't as if everybody got it. And we also delayed the effective date so probation could hire up and we could make sure people would be released safely. So we did that partly because we also had found out, just as you both, the others had mentioned, is the recidivism rates didn't go up at all when we reduced crack cocaine retroactively. And by the way, the Sentencing Commission recently did a report looking at drugs -2, and recidivism did not go up for the reduction in the penalties. So that was one thing I'm very proud of, that the commission was able to do on a bipartisan basis. I don't know if people know, it's a 7-member commission, Democrats, Republicans, evidence-based, and we worked, I thought, beautifully together. 3 other initiatives I was proud of is there's only so much we could do because of the statutes, the mandatory minimum statutes, which were in many ways the drivers of a lot of the sentences judges worried about and drove high incarceration rates. So we did the mandatory minimum report. We did tons of reports, but the one I'm the proudest of was this one, because it became somewhat of the blueprint for the First Step Act that passed. It recommended expanding the safety valve, getting rid of stacking, getting rid of the harshest of the doubling of the penalties, and that sort of thing. And my sadness, I would have to say, is the bill didn't pass while I was there, because I cared hugely and worked hard on it, and passed in the next administration. But it was really, a lot of it was built on the data and the research that the Sentencing Commission did. The third big thing is we started the discussion on compassionate release by holding hearings on compassionate release, because the Bureau of Prisons had almost never used it. The only time I, as a judge, ever got one was when the person died before it got to me. So it was just really a last resort. And we started the discussion about that, which ended up in the First Step Act. And finally, I cared a lot about recidivism, because at core, what we're worried about is public safety. And we've done with our not bad, fabulous staff, amazing recidivism studies, which go 8 years out and don't just look at rearrest, but they look at reconviction and reincarceration to see what we're really talking about in recidivism. So that was my whirlwind tour, and I'll stop right now.
So grateful for that as well, Judge Saris, and some similar themes about data, relationships with Congress, and moving a variety of reform conversations forward. All very valuable. I have a sneaking suspicion Judge Gertner may not be quite as positive about the work of the commission writ large. But before we turn to her, I want to get this crew, and we'll maybe go in reverse order now and start with you, Judge Saris. Even with all those developments and the reforms you helped to spearhead, when you look back at your time on the commission and think about how the commission functions, the sort of the operational dynamics of it, again, hearing about the research staff, how important that is to the work that you do, but are there things that you could imagine maybe tweaking, maybe changing in large regard about how the commission has historically functioned that might be an important thing for future commissions to think about, or just different models, whether it was a frustration you may have had while you were there, or maybe something that's occurred to you in reflection, just in terms of kind of both the day-to-day operation and the overall vision and mission of what the commission does, thoughts about how that could change.
Well, I think towards the end, thank you for asking. I like the structure of 7 members. I think it's just about the right size, the Goldilocks size, just right. I think the bipartisan aspect of it is essential, because when we agreed, Congress very rarely disagreed with what we did. We had no pushback, for example, I think on drugs -2. So it's really important, I think, for us to work closely with Congress and closely together and do it based on evidence, so that people can't say, oh, we were just shooting from the hip, we didn't know what we were doing. I think that one innovation that I put in, and maybe could be expanded, was a committee of federal defenders whom we consulted with more often. They're the only ones who aren't ex officios, which might be something that someone could consider if they would to redo that. I mean, we got huge input from them, don't get me wrong. The DOJ has one, and defenders never did. That's my personal opinion, not shared by everyone. I want to add that, but I do care about that. And the other big thing is, I think big picture stuff, we got a little too clunky on the guidelines. It needs a serious pruning. It needs a serious rethink. And I know Judge Sessions may be talking about that. He has his proposal, but it's almost as if, take the economic crime guideline. Every time someone had an idea, something else was added. And I think it's time to sort of do a fresh retake on it. So I'll stop there. And the other things I do agree with Judge Sessions is we started thinking about alternative courts. We do that hugely in Massachusetts. We've got some of the most innovative judges you can imagine. I think you're hearing from some of them, starting to think more about how you would use alternative courts, like as either alternatives or reentry courts. And I think most courts are doing that. So we need to be studying them. So I'll be quiet.
Oh, wonderful. Thank you. Judge Sessions, go ahead.
Actually, we have a drug court in Vermont. I had it today, and 10 addicts who are facing indictment, in fact, conviction before sentence, go through a year of drug court with, and if they complete it drug-free, they get a non-incarcerative sentence. It's a great model. But what I've found, and I bet Ricardo might have the same observation, Patti as well, is that when one left the commission, one started thinking about, gee, what is the best big picture approach to sentencing? Those of us who believe in guidelines because of, one, the closer consistency of sentencing across the country, and second, the modeling of the issues that are so important in sentencing and telling judges these are the important things, and then also giving judges examples of what other judges are doing. That seems to be a model which is wonderful. So then I started to think about how would you redevelop a guideline system that would incorporate a lot of the discretion that courts have at this particular point, but that also provide a level of consistency so that people in Miami are being treated the same way as people in New York. And so I came up with 2 articles, one in the University of Virginia Law Review, one in the University of Wisconsin Law Review, which essentially suggested wider ranges, taking out the 10% rule or the 25% rule, much wider ranges, a greater limit of discretion with circumventing those guidelines, but still permitting departures outside of whatever guideline structure you have. But then all of the general benefits, that is, some limiting of discretion together with some guidance to judges on what factors are particularly relevant, and some way of judges learning about the history of what other judges are doing in that regard. So it would involve a guideline system that would have much wider ranges, much fewer numbers of ranges, but also would have the alternative of actually going outside the guidelines in extraordinary circumstances, but some heightened level of control within the guideline structure. So I proposed that in 2011, and it didn't get adopted, and Perhaps it's outdated at this point, but I really think that the next commission, when they begin again, should actually take a fresh look at what kind of guideline structure would satisfy both the Congress's input into sentencing, the president's input into sentencing, but also would accommodate the need for discretion with judges to be able to weigh all factors in determining what is an appropriate sentence. Okay.
Well, I'll jump in to say, Judge Session, I don't think your proposal is outdated, and my indicator of that will be, I believe, Judge Pryor, who went on to chair the commission, the most recent acting chair, proposed something quite similar even more recently, because I think the roles that you all have served in, give you a perspective that even if you have different perspectives on other issues, lead you to a similar kind of model as a suggested reform for the federal system. And with that, I will now finish up with Judge Hinojosa, and then get Judge Gertner into the conversation about both these sort of big picture reflections, looking back and looking forward as to how we can learn from the past and move forward effectively.
Yeah, well, Judge Saris brought something to my mind, and that I felt very strongly about when I got on the commission before I was the chair. We were having a public hearing, and the person who was a public defender kept raising her hand, and there was no decision to let her speak or whatever. And finally, I just said, I want to hear from her. And so she stood up and gave her statements and what she was thinking of with what we were discussing. I then, and certainly by the time I was chair, I came to the important viewpoint that I had with the staff, that anything that we were sharing with the Justice Department, we should share with the defenders, that we needed input from both sides before we made any kind of decision. And we did. When I was chair, we shared whatever we were going to share with the Justice Department representatives, because they have an ex officio member, which the defenders do not. We would share with the defenders because they had somebody assigned to deal with regards to the commission. I don't really have a problem with the guidelines that are written now. I think there's plenty of explanation, plenty of notes within each guideline. I will get back to the fact that I know there's some people that will never like guidelines. I found them extremely helpful, and most important because of the fact that it becomes everyone in there, whether you're the prosecutor or the defense attorney, based on the pre-sentence report and the recommendation on the guidelines, has now an idea of where the judge is coming from and what the judge is thinking and why is the judge thinking this sentence. I again say something that the judges that are here did not have an experience of. I had about 5 years with no guidelines. I didn't have to explain anything other than this is my sentence. I found it very helpful when we had a guideline system where there was something given to both sides beforehand in the form of a pre-sentence report, and then also explained from the standpoint of these are some of the issues that the judge is considering based on a guideline manual. And obviously the judge can decide to depart also, but at least there was this open viewpoint that was shared with everyone as to what the judge was going to be thinking about on the sentencing date. I have also found it extremely important to let a defendant speak as much as they want to at the time of sentencing. I have even allowed a person who raises their hand from the spectator section wanting to say something. And I have to say that that comment and my allowing that person to speak was extremely important as to the information that that particular individual had with regards to the sentence that I was about to pronounce. So I have never hesitated to let that happen. And sometimes I indicate that I have received this letter and I would like to say this, and do you all have any comments about this? Or I find that very helpful. And I find it helpful when a defendant speaks. I find it helpful when the prosecutor speaks, or for the victims when we have a victim situation. There are very few cases that we have actual victims as opposed to society as a whole being the victim, but I think those are important.
Thank you, Judge. I really appreciate that. And Judge Gertner, you've been very patient as you've heard talk of past and visions of the future work of a commission. Would love to hear your perspective on those questions. And I know more generally that you've written a terrific new article about reimagining the role of judges in sentencing. So hopefully you can speak a little bit to to where that fits into your own vision about where a future commission could be going, learning from some of the experiences of the past.
Well, it is wonderful to be on the same, at least to share a screen with old colleagues. And I don't mean old, I mean former colleagues. I too, like Judge Hinojosa, wasn't a judge during the pre-guidelines period, but I was a lawyer during the pre-guidelines period. And I've had the opportunity to be both a judge and an academic in this area. So to be both a judge and a critic and evaluate what we have been doing. The federal sentencing guidelines, the bones of it, were done at a time before we understood the impact of mass incarceration, before we understood racial disparities, before we understood the neuroscience of addiction and the ways in which the addicted brain is different, before we understood the impact of trauma and ACEs scores. And the bones of it reflect that. The framework of the guidelines itself, sure, there have been wonderful changes that has been reflected in these conversations, but the bones need to be re-examined in a fundamental way. This was also the guidelines were promulgated before we understood that disparity meant more than just what I was doing in my courtroom. Disparity also was reflected in what prosecutors were doing all around the country, the extent to which they manipulate guidelines, the extent to which, in fact, the charging practices in Florida are different than the charging practices in Massachusetts, and yet the same individual in Massachusetts could wind up with the same sentence as the guy in Florida for essentially the same quantity, but they was standing of drugs, but he was standing on the corner over a week rather than someone who was doing this in a single shipment. I mean, the guidelines were promulgated in 1987 for the purpose of dealing with disparity and nothing else. And in the intervening years, we now know what the else is. I appreciate what Judge Hinojosa said. Judges can be given guidance without this sledgehammer. Judges can be given guidance in the same way we deal with discretion with other players. We can talk about clinical studies. We can talk about sharing statistics. Guidelines in the form of the sentencing guidelines, which was adding a number for each additional harm. I mean, that was the framework. Adding a number for each additional harm effectively ratcheted up sentences. And adding a number, again, another driver of the guidelines for the criminal record without a view to the role of racial disparities in policing increases the guidelines. To be sure, the guidelines are now advisory, but the Sentencing Commission statistics make it clear that they are still overwhelmingly followed. And in fact, in a very troubling statistic, the Sentencing Commission says 50% of the time judges follow the guidelines and the remaining 30% are when the government agrees. I don't regard that as a meaningful system where we count government agreement in pleas as part of compliance with the guidelines. The commission statistics, the commission staff, certainly important staff, but for the most part, and there are some exceptions for sure, the commission staff has been focused on legitimizing the guidelines, not looking afresh at what it takes to stop drug distribution, not looking afresh at what it takes to stop the various crimes that the guidelines were supposed to address. Judges are taught. I think that Booker advisory guidelines are largely illusory, and they're illusory because when you look at the way judges are taught guidelines, they are taught, there are like 20 slides about guidelines and guideline computation. And then the last slide is, by the way, these are advisory. Small wonder that judges don't exercise their advisory judgment, in my view, in any meaningful way. I could go on and on and on, but in addition, I believe the guidelines are vulnerable in another way. We have a delegation skeptic Supreme Court. that talks about the Environmental Protection Agency not having sufficient empirical basis to its regulations, or talks about OSHA and is critical of OSHA. The Sentencing Commission, sadly, is a junior varsity legislature. Is a junior varsity legislature. And to all intents and purposes, the very consensual nature of it makes it clear that these are political bargains and not necessarily empirically grounded in the way another agency would be. So I have lots of suggestions, but I think each and every guideline needs to be re-examined for its impact on mass incarceration, its impact on racial disparities, and whether or not it actually is the most effective way of affecting public safety, which is a fundamental re-examination.
Thank you, Judge Gertner. And I'll actually turn to you with my sort of one follow-up question that's going to then extend to the other judges. And it's, you know, it's this part of the broad question of what advice you might have for a future commission based on one of your comments. And there's so much there we could focus on, but I'll drill into this idea of educating judges. Do you think it's the commission's role? Do you really think it's the commission has the ability to educate judges on a range of factors and a range of considerations outside of the particulars of the guideline, which of course are challenging enough to get a handle on? Is it that
I mean, the commission has a website. If the website included, the website endorsed diversion programs as opposed to it being the aside in every court. Your court wants a diversion program, you can do it, but not as a national standard. If it endorsed, for example, what we now know about addiction, for the neuroscience of addiction, we know what works. If it endorsed the consideration of trauma, I'm writing about the men I sentenced, and their bodies, their physical condition reflects the trauma that they went through. How does that figure into sentencing? All of this could go on the website of the Sentencing Commission. And then, although this may sound narcissistic, the Sentencing Commission's website never included the decisions, the written decisions of district court judges that could well be a template for other judges. Sure, my decisions, Bennett, Gleason, all across the country, you've taken the time to consider a non-guideline sentence, and you want to show other judges why you did that. For as far as the commission is concerned, they don't exist. The commission has, appellate review of guideline sentences, which in my view is largely incoherent. So there are ways the commission could encourage alternatives in the way they train judges, and frankly, in what they endorse on their webpage.
It's a wonderful insight that I'm tempted to turn to the other judges to kind of frame it this way, which is there's a considerable debate, especially after Booker, as to how much of sentencing is guideline centric. I think that notion that the commission has remained quite guideline centric. Certainly the commission's website is guideline centric. The collection of data is guideline centric. And it sounds like Judge Gertner saying, that's a good and important face to the world to judge whether or not the commission is sort of moving away from a set of guidelines that she thinks is very problematic. I know Judge Hinojosa, was suggesting the guidelines aren't problematic at all. There's nothing wrong with being guideline centric when you think the guidelines are doing an awfully good job for what they're aspiring to do. Without getting into that debate too much, I'm eager to hear from the former chairs about what advice you'd give to future commissioners, how you would suggest, you can do it either kind of it's their first day on the job, I assume play nice with the staff and learn the building, but thinking, both short and long term, how we've had this period without a commission for a number of years. I've heard a number of people saying that provides a unique opportunity for a kind of fresh start. But what does that look like? Should the First Step Act, which still needs to be fully implemented, should that be a priority? Your own sense of how the new folks getting on the job, and it looks like it's going to be another slate of 7, or at least that's sort of the talk since since the commission's been depleted without appointees for a while. So there's a whole commission to talk to. I'd love to hear your advice and thoughts about how they should go about what's always a challenging job, but maybe even more in these days.
Can I respond?
Jump in, please.
Yeah, well, first of all, I don't think the commission's or sentencing guidelines are in any way causing the racial disparity that we have in this country with regards to people being sentenced. I think that's either regional or something else, but it has nothing to do. In fact, quite to the contrary, the purpose of the guidelines is so that everybody gets treated the same, regardless of what race, or regardless of whether there is non-citizens or citizens. And it works very well because it doesn't make distinctions between races or citizenship. It just gives you a set of guidelines. And I think that that's important. And yeah, there are people that are being sentenced outside the guidelines. A lot of it is government motions based on cooperation and assistance, which is any good defender is going to be talking to their client about, is there any way you can help yourself? That does all sorts of things, including getting rid of mandatory minimums in a particular case, as long as the government is in favor of it based on cooperation and assistance. The commission's work is pretty open with regards to comments from all sorts of places. A lot of it is the data. And, you know, the other thing that, and Nancy and I are friends, although she's a law professor, we are a very big country and we have very different viewpoints as a country as to whether you're from Texas or whether you're from Massachusetts, for that matter, as to how you view things. The purpose of the guidelines is that when you commit a federal crime, it doesn't matter that you're in Boston or McAllen, Texas. The same factors should be considered by the judge with regards to, because the harm to the country is the same. These are federal convictions. I mean, so that is the whole purpose of a guideline system, to try to get rid of that kind of disparity. And we had it certainly without the guidelines. I mean, somebody in Boston might send somebody very differently than a drug case in Texas, for that matter. And this is an attempt to make sure that we have all the same considerations. And the one thing that bothers me is that judges do not understand that under the policy statements of the Sentencing Commission, if you want to depart from the guideline determination, you can easily find in that manual the reasons to use, rather than saying, I'm just doing a variance on my own. In fact, it would be very helpful to the commission if you use something from that policy statement section where you have the different reasons for departure. If the commission had enough information that judges are doing this and this and this a lot on as a departure, maybe we should do something with regards to the guideline itself. And I think that would be extremely helpful if people understood that. But I think the commission needs to do a better job of letting people know that we do have policy statements in case you want to depart. And this is what they are, and this is how you can use them if you want to and find it appropriate. Being a user of them myself.
As a law professor who got tenure by saying there's authority to depart when the guidelines were mandatory, I won't in any way contradict Judge Hinojosa's inclination that aspect of the system, still lives, and that may be part of the advice to the commission, that they kind of remind judges nationwide and try to document and demonstrate the value of.
I had a discussion with a member of the commission when I kept saying the policy statements are reasons for departure. And that person could not agree with me that we should be talking. I said, it's important. It's a big part of the policy statements are supposed to be with regards to, do we have reasons why you might depart, and give some guidance. And I said the commission should teach that more. And I was the person I was talking to was a member of the commission who did not agree with that, but I find it very important.
Judge Saris or Sessions, jump in as you
go ahead.
Well, I was just going to say, Judge Gertner reminded me of something which is that needs discussion, which is the prosecutorial, the role of the prosecutor in this whole. When I was there, I found fascinating that we convened prosecutors from all over the country, and she's quite right. They're very different charging decisions depending on where you live, and my guess is a fair amount of. My sense is that most judges know very well their ability to vary and depart, and that many of the things that may be captured by the guidelines may be trapped by the mandatory minimums. In fact, we found some of that. So I do think that training is always good. always. I think we do it in our national training seminars. At the Federal Judicial Center does it. In my experiences, they do talk about variances and departures. But to come back to the basic thing, I think that one thing that structurally needs to be worked on, as you said, Doug, it's the First Step Act, is people need to sort of study the commission, some of the mandatory minimums, and see how much that they're having some of these impacts on how people are being charged and how that's being done nationally. So I just wanted to add that one thought in there.
Thank you, Judge. Judge Sessions?
Yeah, if I can add, I love to listen to Nancy, and what I find most interesting is that usually I find myself nodding yes. I agree with that, and I agree with that, and I'm a person who happens to believe that a guideline system would be good for the country and good for individual sentencing judges. So as I was listening to Nancy, I was thinking about what exactly is the objection. So there are two fundamental questions. The first is whether there should be a central body. I mean, after all, the Sentencing Commission was, at least philosophically, created to provide expertise in the field of sentencing. And I think most everybody would agree it would be very helpful to have a body of experts who would be able to explore the impact of opiates on the ability to create intent, those kinds of contributions. The expertise that goes with the study of sentencing would be very helpful for judges, and also helpful in creating a discretionary guideline system. So the more difficult question is that when you agree that there should be this body, then the question is, how much discretion do you give them? And sentencing is really an interesting process, because every branch of government wants a share of sentencing, right? You have Congress, who has a real interest in sentencing, enforcing the laws. You have the president enforcing the laws. You have Congress making the laws, and judges as well. And everybody wants a piece of sentencing and feels that they should be able to contribute to what is the appropriate sentence. So when one starts to think about creating a guideline system, it's not just what judges want, unfortunately, because it's not just judges who contribute to sentencing. It's Congress has a legitimate interest in sentencing. The president has a legitimate interest in sentencing. And it seems to me that, I mean, I'm big into judicial discretion, but as one accepts the concept of having a national body being a contributor to what is a national sentencing process, that we should really be thinking about sentencing from the global perspective, including the interests of Congress, frankly, and of the president. And that's where it becomes incredibly difficult. I think the criticism that could be made of the Sentencing Commission is that oftentimes we may have bent over backwards to make sure that we did not offend Congress, or to offend the president, et cetera, or to work with them, which we did in regard to the crack -2 guideline change. But I think it's important that we think about sentencing in a broader perspective.
It's a terrifically important point. It's one that I know, and I'm thinking of Professor Rachel Barkow's work and some others who have highlighted that a lot of state commissions actually have state legislators on the commission. You know, that's one of the things that's notable. We were talking earlier about the Attorney General as an ex officio member of the commission. So the president, in a sense, gets their voice through the commission, but we historically have not had somebody from Congress, you know, sort of directly represented, although sometimes there are former staffers and the like who played a role in that way. And so, you know, thinking about how that relates to the structure of this body, not just, you know, that an expert body should be there, but who should be part of that body is so interesting. I know we're short on time, but Judge Gertner, I'm going to give you the last word, not only because you've been in all these roles and commented both on matters of structure and substance in the work of the commission. But I just know that you're continuing to sort of think about and advocate about how both judges and the system as a whole can approach these questions more effectively.
I know I have to be brief, so let me be brief. I want to re-examine the quantity. The guidelines are framed by quantity and criminal record. Quantity makes equivalent the guys that I sentenced who dealt crack on their corner for school supplies or dealt crack on their bicycle with a guy who was dealing the same quantity for the purposes of, buying a Porsche and fueling a great lifestyle. The emphasis on quantity with respect to drugs is misplaced and was misplaced at the beginning and should be re-examined because there are meaningful distinctions between those offenders. The emphasis on criminal record is it needs to be looked at again because it failed to take into account the extent to which criminal records are a product of policing in minority neighborhoods. The exclusion of addiction and mental health issues from the guidelines, which served a purpose in 1987 to rope judges into a consistent pattern of sentencing rather than exercising discretion, we now know is wrong. It's not just wrong in the sense that this or that court should have a drug program. It's wrong fundamentally, since these things matter in terms of sentencing. So I think we should re-examine the entire structure to look at whether, and they may have made sense in 87, but they do not make sense in 2022.
That's a wonderful sort of closing sentiment. I want to thank everybody involved in putting this together, and particularly our four judges for sharing their wisdom and their time, because these are such important conversations, and we'll be continuing to have them because with luck, we'll have a new commission in place, and hopefully all of you will continue to share your deeply wise insights into the work that they do for the benefit of us all.
All right, I think that we are back to live. So I just wanted to take a moment, and Chandra and Eloise and Rachel, our wonderful CJHD staff, will be looking to see whether or not there are any last minute questions that come into our chat in the final moments. But we really just wanted to take a few minutes to thank everybody for joining us today. Unfortunately, fortunately, we've had such wonderful panelists who are extremely busy and have really packed schedules. So the unfortunate part is that they're not today able to join us live to answer any question and answers. As you know, three of our wonderful speakers are currently on the bench, and so they're doing their day jobs, and we are certainly grateful for the time that they were able to give us. But certainly if there are any questions that you would like to submit, we will bring that back to our four fabulous panelists, as well as our moderator, Doug Berman from the Federal Sentencing Reporter, and are happy to kind of have them answer those questions on their own time. And that is something that we can post and publish on the CJHD website. I'm looking at a question that did come in from our dear friend and former panelist on our week one. And the question is, I'll read this out loud just for the benefit of the audience, but then know, Mr. Ayala, that we'll have the real experts answer this question. The question is, I'm a federal defender working in our collaborative courts for the past 10 years. Can we realistically expect the commission to encourage the establishment of such courts across the country? Probably meaning alternative to incarceration or problem-solving courts. We operate without support from outside of our local district. And that is from Raul Ayala, who again was our speaker, one of our brilliant speakers from week one of our panel series, the Federal Alternative to Incarceration panel. I will not claim to be any expert, and Raul definitely knows more about the likelihood of the Sentencing Commission kind of bringing uniformity and universal standards, protocol, or support, whether that is codification in sentencing guidelines or doing research to support the proliferation of federal ATI programs. But I guess my 2 cents, for what it's worth, and it might be only worth 2 cents, is that from what I've seen from the sentencing commissioner nominees, I'm very hopeful about the future of the Sentencing Commission. I think we've all kind of followed and have been encouraged by the writings of people like Professor Rachel Barkow, who works out of NYU Law and who we've been lucky enough to kind of have as an informal advisor at the Center for Justice and Human Dignity on some of these matters. And certainly, you know, as an organization that has spent the past 8 to 9 months really trying to research federal sentencing reform, and specifically the role that the United States Sentencing Commission can play, there does seem to be a groundswell and excitement around having the Sentencing Commission maybe play an active or productive role in kind of fortifying more alternatives to incarceration, or as our friend and another panelist said, and that is Judge Leo Sorokin, kind of additional supplemental and not just alternatives to incarceration, but really looking at how alternative responses and restorative justice principles can be embedded within the federal sentencing system from the start. And I think that was a really important takeaway, certainly from our first week's panel, but throughout this panel series. And hopefully for those of you who have joined us all 4 weeks, certainly that's something that our team has learned, is that these alternative to incarceration programs, these really productive and holistic sentencing practices don't just have to exist in a vacuum within individual courtrooms or individual teams, but that federal sentencing as a whole can support these maybe more open-minded, productive, proactive sentencing alternatives, which I think is a really exciting space to be in. So I will check the chat once more, but please know that all questions will be logged and then sent back to our panelists, who are the actual experts. And so you'll be getting some more feedback, which can be found on the Center for Justice and Human Dignity website. That's cjhd.org. But for now, we're going to sign off. Another huge thank you to our whole staff at the Center for Justice and Human Dignity, who really made this panel series happen. That's Eloise Caney, Shundra Williams, Rachel Van Etten, our supporters at the Olive Institute, who have incubated the Center for Justice and Human Dignity, but most especially a huge thank you to our incredible panelists over all 4 weeks of May. We would not be able to be facilitating and hosting such a robust communication and conversation around such an important topic like federal sentencing reform. And then I would be remiss if we didn't say a big thank you and shout out to Doug Berman and Steve Chanenson, the editors and gurus in the federal sentencing reform space, and editors of the Federal Sentencing Reporter. And just know that this conversation will continue on within the October 2022 edition of the Federal Sentencing Reporter, and more information can be found on CJHD's website. I think that's all I've got. Thank you again for joining us, and we look forward to continuing a conversation about more effective, efficient, equitable, and fair federal sentencing practices moving forward. Take care, everyone, and be well.